I swear, without fail, every time I push the go live button, my dog starts barking. She just knows. Every time. My husband just got home. That's why she's going crazy. So by the time I'm ready to start, she'll hopefully stop. I just think it's hilarious. She does it every time. Gotta love her. Yeah, thanks, Dawn. Hi, Justice. She's officially the most uncooperative dog ever. Thanks for joining me last Sunday afternoon. I haven't looked outside yet, but we're actually supposed to get another 4 to 8 inches of snow tonight, so good times. I can't complain too much because Manitowoc is actually supposed to get 12 to 15 inches, so at least I'm not up there. Hi, everyone. Oh, thanks, Allie. We're hoping my husband walks in the door in a minute so she stops barking. And you can tell he walked in. So yeah, so I'm gonna get started in a couple seconds. I just want to wait till a certain animal starts cooperating and stops barking. You know, your puppy. Okay. Hey, Jim. Long time no see. Okay, not too many here yet. I actually am doing this a little bit later than I planned, just because there's so much that I wanted to read and I wanted to go through before I started talking about it. And I didn't get to read as much as I wanted to, and then I had to try to organize it in some way. This video, like some of the others, is going to be very heavy on quotations and citations and case law. And so I hope that I don't start boring everybody because I will be reading a lot. Again, I try not to, but my memory is only so good. So I kind of have to read stuff to make sure I get it right. Hi, Paul. So I am actually calling this video The Madness of Youngblood because it is just, yeah, it's hard to explain. There's actually a lot more that I still want to read, but I had to draw the line somewhere to get this video done. Okay, so I need to get started. Okay, first off, I have a lot of new people, both on YouTube and in the group. So I just want to talk for something for a minute here that kind of explain what I do. A lot of people have been here with me for a long time, so you get how I work. I am most definitely a supporter, but when I talk about the legal stuff, I try to do it as impartially as possible because I want to make sure that my expectations are managed. Okay, I don't want to just read something and get all excited because every attorney is going to make something sound good. You know, in order to know whether a brief, a motion, whatever it is, in order to know like how good it is to actually dig into it a little bit. You know, make sure that you're keeping the lawyers honest and that they're not doing any crazy citations or that they're not like misconstruing the statutes or whatever just to make it sound good. And everybody does this. It's not just the state. It's just not Kesey. It's every lawyer does it. Thanks, Travis. And so occasionally it will appear to people that I'm like bashing Kathleen or that I'm complaining about it or that, you know, like I'm just a Debbie Downer all the time. And I'm not. I really just try to give the facts. I give the information on these laws. And what you choose to think of it after you hear it is up to you. Okay, sometimes people ask my opinion, I will give it, but it doesn't mean I'm right. You know, I mean, I'm wrong about a lot of things. So it's just that I have usually read a lot more, you know, so that's why sometimes my opinion may be a little bit different than other people's. I have spent the last 3 days reading so much on this case, reading so many cases about preservation statutes. And as usual, when I do these videos about the statutes, it's a giant mess. It really is. I always say it's clear as mud. I say that like half the videos I do. I said by the time you're done, you won't necessarily understand what's going to happen any more than you did before we started, but you'll have a lot more insight into it. Now, again, you know, just because I might say something that sounds negative, that doesn't mean that I'm against anything. I'm not against Kathleen. I'm certainly not against Steve. Steve and I are actually really close. So I want to get justice for him as much as anybody, you know. So yeah, I would never want to do anything that would hurt that. Hi guys. Okay. So anyway, so first off, I need to give a huge thank you to my girl, Jennifer. You guys have heard me complain endlessly how I wish I had a subscription to Westlaw or Nexus or LexisNexis, whatever. And I don't. And so that means that when I find all these obscure like Wisconsin Law Review articles I want to read, I have to go to Jennifer. And she has been so helpful in getting me anything that I need. And I just have to give her a big thank you. She keeps telling me to stop thanking her, but I'm going to still thank her anyway, because she's a lifesaver. She has made things so much easier on me. So anyway, I didn't want to forget to do that. So I'll get my iPad here. Okay, so again, we're going to focus on Arizona versus Youngblood, because that is one of the primary cases that Kathleen is arguing this motion under. The one thing I want to make clear, and I don't think I made it clear in the other video, is that is that there are two separate issues here that she's trying to win under. Two separate legal claims. One is under the statute. It's a statutory claim, okay, under the 968-205 preservation of evidence statute, okay? And if they're basically not going to look at that one, then she's saying, well, then like this should win because of Arizona versus Youngblood. So it's two separate arguments she's making, and she just wants to win under one of them, okay? Now, before I forget, everything that I talk about by the end, I still think that the court has to remand this case. The reason being is that they still have to get the facts of surrounding why this evidence was disposed of, okay? And most of these preservation cases I've been reading have had hearings. Not all probably, but most have. And so again, you know, there's no reason that a hearing shouldn't be granted. I say that knowing full well that anything can happen and this judge is not our favorite, but it still should be. I mean, because again, how can you properly evaluate whether the evidence was disposed of in bad faith and all that other stuff if you don't find out from the other side their reasoning for doing it? You can't. So it should legitimately be given a chance to be, yeah, a remand is good. Yeah. So, I mean, they have to have a legitimate chance to actually evaluate this issue fully. Okay. So the preservation of evidence statute was enacted in 2001. Arizona versus Youngblood was a precedent set by the U.S. Supreme Court in 1988. So a lot of the cases that you find citing Youngblood were pre a lot of these DNA preservation statutes. They didn't even have DNA testing back then. Most of the cases I'll read will talk about how they were doing blood group type testing, or even just blood testing in general. They would be looking for, with semen, they'd be talking about non-secretors and the secretors and all this stuff. It wasn't like it is now. But that's why this preservation statute is so important, because obviously new technology, new testing can give them a completely different view of or results that can actually either exculpate somebody, you know, or inculpate somebody that's not actually been charged with the crime. So it's really important, which is why it's maddening that the state refuses to actually address this statute. Yeah, I'll get back to that, more to that later. But in the state of Wisconsin, the controlling case is State versus Greenwald, which is completely based on, we talked about this last time, about the Trombetta case and the Youngblood case. But they really stand on Youngblood because that's the more difficult one to overcome. So That's why Kathleen is putting it in this one, because under Trumbetta it says that the information has to be apparently exculpating, but that's not going to be the case with these bones. It's not going to be that obvious. But they are potentially exculpating, and that means that then she has to satisfy this bad faith requirement under Arizona. Let's see. Yeah, so there's two parts to Greenwald. It just says that it's a due process violation if the evidence, if law enforcement failed to preserve evidence that is apparently exculpatory, or acted in bad faith while failing to preserve evidence that is potentially exculpatory. And obviously these bones are more potentially exculpatory than apparently. So I'm just going to talk about Arizona versus Youngblood first. Okay, well, actually, that's most of what I'm going to talk about. Okay, this case was a case in 1983 where a 10-year-old boy was abducted from a carnival. His abductor sexually assaulted him numerous times, and about an hour and a half later returned him back to the carnival. He threatened him and told him he'd kill him if he told anybody, but yet the boy still told his mother right away. He was taken to the hospital. The doctors determined that he was sexually assaulted. They did a rape kit, so they took samples of saliva, blood, semen. Can't remember if there's anything else. But they also took, let's see, saliva, semen, blood, and hair samples. That was the fourth thing they took. They also took his t-shirt and his underwear. Problem is that the samples, the biological samples, were properly refrigerated as they should have been. The t-shirt and the underwear were never properly preserved. They kept them, but they were never preserved. It was, I believe, 9 days after the attack that the little boy pointed out Youngblood, Larry Youngblood, in a photo array lineup. He was arrested 4 weeks later because they couldn't find him at first. Once he went to trial, or was in pretrial, the state actually moved to have Youngblood's blood samples, semen samples taken so they could compare them to the samples they had. And it's weird because the court actually denied it. They denied it, saying that the state didn't have any samples that were big enough to compare them against, even though the testing hadn't actually been done yet. It's a really weird ruling. It's really weird that they would deny the state the option to take samples from the defendant. It's just really strange. They did ultimately do the testing on the biological samples, and they determined that nothing could be found by them at all. It wasn't until a year later that they decided to finally test the t-shirt and the underwear. And at that time, they couldn't determine anything that would be helpful as far as identifying the perpetrator. So Youngblood was ultimately convicted on the eyewitness identification of the little boy. That's it. The criminologist who had done the testing on the t-shirt and underwear actually testified during court that it was his belief that if the t-shirt and underwear had been preserved properly or had been tested earlier, not a year after the crime happened, that they may have been able to get results that could have been helpful towards identifying the victim. So Youngblood, after he was convicted, sought relief on post-conviction, arguing that the police improperly preserved the t-shirt and underwear. Already misspeaking. If the police had properly preserved the t-shirt and underwear, biological testing would have exonerated him. The case actually went to the Court of Appeals, and the Court of Appeals reversed his conviction, stating, when identity is an issue at trial and the police permit the destruction of evidence that could eliminate the defendant as perpetrator, such loss is material to the defense and is a denial of due process. Of course, then the Arizona State Supreme Court denied review, so the state petitioned the U.S. Supreme Court to take a look at the case. Sorry, I'm just going to look at the comments. Yes, if there's a hearing, that it would most likely be allowed to the public unless the court closed the proceeding. Okay, yeah, you guys are getting ahead of me with some of these questions. Okay, I'll get to it. Okay, so ultimately the US Supreme Court, as we know, reversed the Court of Appeals decision and reinstated Youngblood's conviction. So here's where we go with this. Okay. The majority held that unless a criminal defendant can show bad faith on the part of the police, failure to preserve potentially useful evidence does not constitute a denial of due process of law. The court thus held that the failure by police to preserve the semen samples, though possibly negligent, did not result in a violation of Youngblood's due process rights because no evidence of bad faith was brought forth by the defendant. In order to be granted relief on grounds of a violation of due process, the court held Youngblood would have to prove the existence of bad faith. Now, this was a 6-3 decision. Okay, so there were dissenters. It's actually a 5-4 decision when you talk about the issue of bad faith, because Justice Stevens concurred on the opinion overall, but he disagreed with adding the bad faith component to it. He wrote a concurring opinion saying that he agreed the conviction should stand, but he didn't agree with the inclusion of a bad faith requirement. He said, "I concur in the court's judgment. I do not, however, join the court's opinion because it announces a proposition of law that is much broader than necessary to decide this case. It states that unless a criminal defendant can show bad faith on the part of the police, failure to preserve potentially useful evidence does not constitute a denial of due process of law. In my opinion, there may well be cases in which the defendant is unable to prove that the state acted in bad faith, but in which the loss or destruction of evidence is nonetheless so critical to the defense as to make a criminal trial fundamentally unfair." Justice Stevens felt that with regard to a black letter rule of law, it was simply too heavy of a burden to place on the defendant to require him or her to prove bad faith on the part of police in order to succeed on a claim of a violation of due process. Now, Justices Blackmun, Brennan, and Marshall dissented on this case. They stated that the court had taken a radical step, especially in comparison to previously established law decided by the court. One issue that was argued was the fact that their decision under Brady, which everybody knows what a Brady violation is now, which governs the rules of discovery, that they had ruled that whether the prosecutor acted in good or bad faith is irrelevant to the analysis of a discovery violation. So they're saying, so why is it any different for this? And the majority stated that since a Brady violation includes the requirement to prove prejudice, or other words, prove that the outcome of the trial could have been different, that no showing of bad faith was necessary. This requirement can't be included in a destruction of evidence issue, since it's impossible to know what the outcome of any testing would have been and whether it could have potentially changed the outcome of a trial. That's why the bad faith component was necessary in this case, but not under Brady. The dissent disagreed, concluding that to suggest that proving bad faith is the only way in which the due process clause can be violated cannot be correct. Regardless of intent or lack thereof, police action that results in a defendant's receiving an unfair trial constitutes a deprivation of due process. The Constitution requires that criminal defendants be provided with a fair trial, not merely a good faith trial, or good faith try at a fair trial. Respondent here, by what may have been nothing more than police ineptitude, was denied the opportunity to present a full defense. That ineptitude, however, deprived respondent of his guaranteed right to due process of law. Still, the majority insisted on the inclusion of the bad faith rule by saying, "We think that requiring a defendant to show bad faith on the part of the police both limits the extent of the police's obligation to preserve evidence to reasonable bounds and confines it to that class of cases where the interests of justice most clearly require it, namely those cases in which the police themselves, by their conduct, indicate that the evidence could form the basis for exonerating the defendant." They said this decision stems from our unwillingness to read the fundamental fairness requirement of the due process clause and imposing on the police an undifferentiated and absolute duty to retain and to preserve all material that might be of conceivable evidentiary significance in a particular prosecution. They don't want to impose. That's basically what they're saying. they don't want to impose something like that on the police. They don't want to tell them they have to collect and save everything. They just don't want to inconvenience law enforcement any more than necessary. The ruling essentially says that as long as law enforcement doesn't get up and admit that they did this, maliciously, and as long as they don't admit that they knew it had any exculpatory value, there's no bad faith. So there's no due process violation. It's at best merely negligent, and that is not a violation of due process. I know, it's frustrating. Okay, you guys are gonna have to you guys are getting questions that I'm not even talking about here. We'll get back. So I don't have any current statistics, but one of the law review articles I read was what was written in 2007. It's a really great article. And I was shocked. I was shocked by the fact that as of 2007, now remember that Youngblood was established in 1988. It's almost 20 years later, 19 years later. 1,675 cases had cited Youngblood on the destruction of evidence. Only seven out of 1,675 had managed to overcome the bad faith requirement. It's kind of a staggering statistic, and potentially, not very hopeful for sure. Yeah, Travis can probably answer a lot of your questions while I'm talking. So again, 1,675 cases and only 7. That doesn't really encourage anybody to think that they're going to win on this claim. Now, this is why it gets interesting. Even though Youngblood is precedential and creates a standard for federal circuits, it does not necessarily carry the same precedential value in the state courts. And the reason why that is because we have a U.S. Constitution and each state has their own Constitution. If a state feels that their own Constitution is not as square on an issue as the U.S. Constitution, then they can set their own precedent on a certain constitutional issue. Okay, so unfortunately, in Wisconsin, in the State versus Greenwald case, the court said that since the state of Wisconsin's Constitution is pretty much on par with the U.S. Constitution, that Youngblood should apply and should be instructive when they made the Greenwald ruling. So yeah, we're kind of screwed in Wisconsin. I read an article, but it was from 2000, so I'm not sure how up to date it is. But at the time, there were 13 states, I believe, that were not using Youngblood. They rejected it. They went in favor with a balancing type of analysis, where bad faith, the intent of law enforcement was one of the components, but there were a lot of other things they took into consideration, and not just that. And they weighed it against the harm done to the defendant, and that's how they determine whether it's a violation or not, which actually makes a lot more sense. So, yeah, essentially everyone is all over the map on Youngblood decisions, and this is where it just makes my head spin. It really does. In U.S. versus Cooper, the defendant was able to overcome the bad faith requirement because the defense attorney had put on notice to the state that the evidence should be preserved. But in Illinois versus Fisher, which has been cited a lot since then, the U.S. Supreme Court ruled that notice is irrelevant. Contradictory rulings. We all know that the court ordered to be preserved in Steve's case, and unfortunately, these bones were not included in that order. What I'm curious to know, and for anybody out there that is handling FOIA requests or likes to get information, I know there's a group that does that. We have the order of the court. I don't believe we actually have the defense's original request on the preservation of evidence. And I don't think we have Norm Gahn's reply. I would be really curious to see what the defense actually requested to be preserved, and by any chance, did it include these bones? Or if, like I said, or if they did Norm Gahn have a problem with that? Which he should not have a problem with any preservation issues, because He's one of the people that was on the committee that helped establish the preservation statute. Go figure. But we've never seen those. So, I mean, GON could have submitted a response that supported the issue. I really don't know, but I'd like to see them. So if anybody ever gets a hold of those things, please send them my way, because I'm very curious to see. I know we have to go by what the court ordered, but I'm still really curious to see what Steve's trial of defense wanted and what the state agreed to. I just think it would be interesting. One was not Texas. Yeah, it actually listed in the article. Travis, I'm going to send you this article anyway, because I think it's really interesting. But yeah, it actually listed which states were included. But again, it's a little outdated, so I didn't want to like say for sure in any state. Hi, Dan. So yeah. So anyway, where was I? Oh yeah, I was talking about the contradictory rulings. Oh, and I was talking about the preservation. I got totally sidetracked, of course. Speaking of the whole thing with Norm Don being on the national committee, or whatever committee was called, I had it open at one point, to help talk about these preservation of DNA statutes. It was really interesting reading the minutes of that meeting, because you can see how they're both in favor of a preservation statute, but coming from completely different points of view. Barry Scheck's comments, who obviously runs the Innocence Project, his comments are coming from a place of wrongful conviction. Like, we need to preserve this evidence because it could be used to exonerate people in the future. Norm Don, who is a prosecutor, his stance was, we need to preserve evidence to help victims possibly get justice in the future, when at the time of the crime that the DNA was not in the system. So it's two very different points of view, but supposedly they want the right thing. But it's very clear from the statute that the legislature is definitely going on Don's point of view, because if they weren't, they wouldn't have very clearly specified in the statute that the biological specimen has to belong to the victim. And that's a really important part of the statute. I mean, it's not all biological material. It's material that belonged to the victim, which basically infers that they're looking at it from a point of view, as Gon said, to be able to prosecute in the future cases where the perpetrator wasn't in the system at the time of the crime. But if you save these rape kits and you save this information, maybe they will pop up if you run them at a later date, or if you test them at a later date. That's my opinion anyway. Let's see. Okay, in U.S. versus Bull, Dave, are you on? Because I got to give my shout out to you, because I know you said nobody mentioned it after the motion. In U.S. versus Bull, the court determined there was bad faith because the state was put on notice to preserve the evidence, just like in the other case, and the defense requested access to the evidence before it was destroyed. That seems like it should be a no-brainer. Okay, so Bull won because of that. But in U.S. versus McClure, which had similar circumstances, the court ruled that even though the evidence was requested before it was destroyed, there was still no bad faith. So this is a very clear situation where the evidence was requested, the state still had it in custody, and instead of turning it over, they destroyed it. But there's no bad faith. It's great. It's like, thanks for playing, just go home now. Yeah, it's ridiculous. I actually put a big sigh here in my notes. There are actually more like contradictory cases just like that. Now, granted, there's only 7 that won. So now the author of the article, though, is still very optimistic, because she said that there's nothing particularly special about the cases that won. It's more of a matter of where they were heard and which court decided the case. That's also, though, very disheartening, because that's not supposed to be the point. The point of having precedent is that it's supposed to be uniform against all the courts. What is the point of establishing a precedent if only certain people follow it sometimes? You have no uniformity at all. And that is a problem. It's a big problem. Now, the issue with the Wisconsin courts in this issue. I have yet to come across a case in Wisconsin, I don't think there is one, where they've ever ruled that there was bad faith on the part of law enforcement. I haven't found any. There might be, though. I mean, again, don't have Westlaw, so hard for me to look, but I have not come across any. All is not lost, though. This is where I'm trying to be somewhat optimistic. In the 2014 Wisconsin Court of Appeals, District 2, and I specifically brought this one up because it's District 2. District 2 is where Steve's case is going to be heard. In State versus Weisinger, Judge Brown concurred with the majority opinion, but wrote a concurring opinion expressing his displeasure with Youngblood. Now, unfortunately, Judge Brown has retired. He's no longer on the bench. That would probably be a good thing if he was there. He said, "I must say that I do not like Youngblood. I simply do not understand how a person can show that the destroyed sample was apparently exculpatory when the sample cannot be tested to determine whether the sample has exculpatory value. It sets up an illusion. It would have been okay if the test was whether the sample could be potentially useful, but that test does not have applicability unless the defendant can also show bad faith. The bad faith component devised by the Supreme Court sets such a high bar, it is virtually impossible to overcome. I am not alone in my distaste for Youngblood. Several courts and commenters have criticized the case, and a number of states have held that their state constitution requires a balancing test instead, and that's what I mentioned before. But our court has held that our state constitutional protections are equivalent to the federal protections in this regard, and so we are bound by it. I see only two avenues for resolving destroying blood sample issue in a manner that would be fair. Our Supreme Court can announce its own standard based on the state constitution, as several other states have done, or alternatively, the legislature could enact a statute requiring that the sample be kept for an appreciable period of time after the defendant is charged. Okay, so if you're sitting there and wondering, like, wait a minute, they already have a statute. Okay, remember what I said before. 968-205 is about the preservation of biological samples of the victim. Weisinger and most of these other preservation cases are with regards to preservation of samples from the defendant. Weisinger's was a drunk driving case, as a lot of these are. A lot of these are drunk driving cases where the blood sample was destroyed before her lawyers had the chance to test it. And since it was her blood and not belonging to any victim, it wasn't preserved. And I just put that this is a pattern in these preservation cases. There is very little recourse when it comes to the state destroying samples that belong to the defendant. There really isn't. Also in Weisinger, Judge Riley dissented. Now, Judge Riley is on Steve's panel, okay? The circumstances of this case are very different, so that doesn't mean that he will rule in this way when it comes to Steve, but, you know, at least there's a little hope. Judge Riley dissented, saying that a criminal justice system that allows the government to destroy the sole evidence of a person's guilt prior to notice. See, that's a very specific thing. This blood sample was the only thing that could prove her guilt. And that's why it was that he's saying that it's important, you know, or it matters that it was destroyed. That allows the government to destroy the sole evidence of a person's guilt prior to notice, charging, or a meaningful opportunity for the accused to inspect the state's evidence is fundamentally unfair. The state Supreme Court has at least seen a little dissension. Oh, that's me. That's me talking. It's not part of the citation. The state Supreme Court has at least seen a little dissension when it comes to the bad faith component of Youngblood. In a 2015 case, State versus Lucky, Justice Abramson expressed her opinion on Youngblood and implores the court to reconsider their staunch position on following it. The majority opinion uses the concept of stare decisis to explain why they can't go against the standard set in Youngblood, and then later adopted it by the Greenwald Court. Abramson disagrees, stating that the Wisconsin Constitution is not so like the U.S. Constitution that they can't diverge from federal precedent. Stare decisis is just let the decision stand, or yeah, whatever, something like that. Well, actually, she says that in the it's just standing on precedent is what it means. It's like when there's a precedent set, we use this concept to say that we set precedent for a reason and we need to stand by it. So she says, stare decisis, let the decision stand, is an essential bedrock principle in our system of justice. To overrule precedent requires special justification. A court must keep in mind that it does more damage to the rule of law by obstinately refusing to admit errors, thereby perpetuating injustice, than by overturning an erroneous decision. She's saying, we screwed up. We shouldn't have ruled like we did in Greenwald, and we need to change it, and we have the power to do so. But you just need to have the guts to do it. Basically what she's telling the rest of the state Supreme Court. And then she goes on, the court has set forth the following factors that typically contribute to a decision to overturn prior case law. And this is important because this is the type of thing that may help Steve, or may help anybody, is that there's a chance that this precedent could be changed. And there are allowances for it. But one of these reasons has to apply. Changes or developments have undermined the rationale behind a decision. I think that applies. There is need to make a decision correspond to newly asserted or ascertained facts. There is a showing that the precedent has become detrimental to coherence and consistency in the law. That one is huge because, as I just said, there's no consistency. There's no uniformity whatsoever among the different court systems. The prior decision is unsound in principle. The prior decision is unworkable in practice. The prior decision was not correctly decided, and the prior decision has not produced a settled body of law. Again, when you have multiple courts ruling differently, you have judges dissenting, you have, there's clearly an issue. It needs to be addressed. And so the fact that a few years ago, she was, Abramson was Chief Justice at the time. She's not anymore, but back then she was imploring the court. Like, we need to do something about this. It's just not right. Is a very hopeful sign. I mean, it's a huge thing to overcome. I mean, it really is. Setting precedent, not an easy thing to do, but it's possible. You just need to persuade a few more people, and there are a lot of new people on the court, so who knows? She went on to say these factors are sufficiently implicated in the present case to justify overturning Greenwald. One of the most, let's see. Okay, then this is the most irritating thing to me about Youngblood. And that is that 12 years after the Supreme Court made this ruling and reinstated his conviction because Ellie didn't demonstrate bad faith in not preserving evidence, Youngblood was exonerated using new technology on that same t-shirt and underwear, which proved that he didn't commit the crime. Yeah. So you'd think that the fact that they kept an innocent man in prison for 12 years because he couldn't overcome an almost impossible standard and then was later to be proven innocent, it's like it hasn't changed your stance on the bad faith argument. It's crazy to me. Clearly it's flawed. I am probably going to have to read through a lot of these comments tomorrow. I mean not tomorrow, but after I'm done with the video, because I really need to get someone to help me with this. Speaking of which, I was going to say that if you haven't subscribed to my YouTube channel, which I've never really told anybody to do, but I noticed when I was doing Eric Hosey's video that, you can have another person that can be moderating the comments. So I'm not saying I'm going to do it much because I like doing it in this group, but if you haven't, at least subscribe to the YouTube channel, because I might consider in the future doing a live video there for people that aren't on the Facebook page and maybe want to do the live chat too. So yeah, I go through the comments and it's like they go by so fast sometimes that it's hard for me to know, and I don't want to keep getting sidetracked when I'm in the middle of who was talking. Trina's asking, was Youngblood compensated? I actually did not look into that at all. I was so busy with everything else. Dana, I actually saw your post in the pending, and I think I answered it before when I was talking about the preservation issue. So hopefully I did. I think so. Let's see. Okay, so in his going back to the Weisinger case, that was District 2 of the Court of Appeals, in his dissenting opinion, Judge Riley addresses this concern. He says, we often say that a criminal defendant is entitled to a fair trial, not a perfect trial. The sad fact is that the evidence at issue in Youngblood was, in fact, exculpatory evidence, rather than evidence that might be of conceivable evidentiary significance. Fortunately, preservation of the evidence at issue in Youngblood ultimately upheld the judicial system's truth-seeking function. 12 years after the Supreme Court decided Youngblood and after Larry Youngblood had served his prison sentence, I think he was released before he was actually exonerated. Not sure though. Sounds like it from that line. Advances in science proved his innocence. The evidence that the Youngblood court held might be of conceivable evidentiary significance was the same evidence that later exonerated him. Youngblood may not have received a perfect trial, but at least he was able to clear his name based on the government's preservation of evidence that the majority dismisses as being only potentially useful. And it's a pretty strong statement, actually. Now, Judge Neubauer, who is also on Steve's panel, was also on this case, and she obviously was part of the majority ruling against Weisinger, but she actually didn't rule against her because of the bad faith requirement. She actually didn't address it at all because Weisinger had failed to argue why the evidence was exculpatory, either apparently or potentially. So they never even reached a conclusion on the bad faith argument. Yes, Kimberly, that is my next thing I'm going to talk about. Okay, so is everybody with me so far? I hope so. I've lost some people. I know that this stuff is really dry, and I apologize for that. I think it's important, though. It's important to know where the courts stand on these issues if you want to properly evaluate the strength of emotion. So I hope most of you are still here. Okay, so the next thing I'm going to talk about. Let me open up my new page here. Oh crap, wrong one, sorry. Is that there has only been one case, since that preservation of DNA statute was enacted in 2001. 17 going on 18 years, and only this one case. Okay, and it's State versus Dodge. And it is honestly the most absurd opinion I have ever read. I read this actually yesterday, and I was so just jaw-droppingly outraged that's when I was like, oh, I have to do a video about this. Well, I had a lot I wanted to read because I wanted to talk about all the other stuff, so I didn't do the video right away. And then somebody on the SAIG, Steve Avery's Guilty Reddit sub, scooped me on it. But I'll get to why it's just, I'll get to more later. I'm going to just talk about the case first. Oh yeah, in case anybody's wondering, my YouTube channel is just basically a lawyer. Same thing. Don't look for my name because that's the wrong channel. Just the Basically a Lawyer channel. Yeah. Okay. So I actually was going to just highlight, the key points in it, and I ended up like you can't even see it. Yeah, it's too bright. But I ended up highlighting like the entire thing. But I am skipping some stuff. In this case, Vernon Dodge appeals an order denying his motion to vacate a judgment convicting him of first-degree reckless homicide. He was convicted of beating a 19-month-old boy to death. His claim was that the boy fell down the stairs. There was a lot of evidence to prove otherwise. So I from reading the facts of the case, I don't think he's innocent, but that's not the point for what I'm trying to say here. Okay, Dodge argues the state violated his right to due process by failing to preserve blood samples taken from the victim's residence, and his conviction must be vacated because the destruction of the blood samples violated his rights under statutes 968-205, which is the preservation statute, and 97407, which is the scientific testing or post-conviction scientific testing statute for DNA. Okay, the two statutes that, Kathleen has been mentioning. So, yeah. So this case, I figured I have to read this case. I'm not going to go into all the background and the facts of the case. Dodge moved to vacate his judgment of conviction, arguing the state's failure to preserve the blood samples violated his right to due process, as well as his statutory rights under 96825 and 97407. Following an evidentiary hearing, which, again, pointing out there was a hearing, the circuit court denied Dodge's motion. The court found that the sheriff's department failed to follow its own evidence handling procedures, so they failed to follow procedure, but the failure was not part of any conspiracy scheme or with malevolent intent. So again, no bad faith. Consequently, the court concluded the state did not violate Dodge's due process rights. So the first part of it, they talk about procedural bar. Okay, so this is another issue in Steve's case, and they are actually ruling that he is procedurally barred from bringing these issues, which kind of is like, well, interesting that they continued on to give rulings on the other areas, though, even though they didn't have to. They could have just said he's procedurally barred. The state argues Dodge's current challenge to his conviction is procedurally barred because he failed to raise it in his response to a no merit report. A no merit report is kind of like an appeal. It's filed at the same time an appeal would be, but you're basically saying there are no appealable issues. That's it. You're just putting it on the record. We agree, and the court said we agree. Although Dodge argues his conviction must be vacated because the state's failure to preserve the blood samples prevented him from obtaining post-conviction DNA testing, the essence of his argument is that the blood samples should have been tested before trial to see whether the blood belonged to the victim. Okay, so let's see. Dodge did not raise, I'm trying to figure, I actually have comments here, and that's why I'm confusing myself here. Yeah, Dodge did not raise this argument in his response to the no merit report. A defendant may not raise issues in a subsequent post-conviction proceeding that he could have raised in response to a no merit report, unless the defendant demonstrates a sufficient reason for failing to raise the issues in the no merit appeal. You can just substitute no merit for direct appeal, whatever. It's the same procedure. Like if you didn't bring it up in your direct appeal, then you can't bring it up later on. Dodge has not demonstrated any reason, let alone a sufficient reason, for failing to argue on direct appeal that the blood samples should have been tested before trial. He does not claim that either his trial attorney or his post-conviction attorney was ineffective for failing to pursue the issue. A couple things interesting about that. The testing of the bones was never done by the defense, nor was it requested by post-conviction or appellate counsel. Will it make a difference that they didn't request to do the bones? Because the state did, and the tests were inconclusive. Was there any, burden on the defense to still try to test them? Kathleen actually did file an IAC claim against them in the original petition that she filed for failure of trial counsel to present a competent forensic anthropologist to establish that the bones in Manitowoc County pit were human. So the arguments in here don't apply or shouldn't apply because she actually is filing an IAC claim against them. Now, granted, this claim is coming well after the evidence was disposed of. So it's just one of those things that I keep in my mind that I'm like, well, I'm interested to see how this is going to do it. And this is also a situation where it's new testing that's available. It's not a matter of like, they just didn't want to bother with it. They had no reason to think that the current testing would give results any different than what the state had gotten. The whole reason why she's requesting these bones now is because there's new testing available. Moreover, an issue that has been finally adjudicated in one post-conviction proceeding may not be raised again in a subsequent post-conviction motion. Consequently, Dodge's attempt to challenge his conviction in his second appeal is procedurally barred. I'm a smart ass, even in my own comments sometimes. It's funny. Yeah, thanks. It's giving me the comments not at the place that I put them, so not really helpful. Thank you. Okay, hopefully I'll figure it out. The state argues, oh, actually, totally missed it. Yeah, I'm trying to figure out what this comment was. Oh, yeah, that's what it was. It was my smartass remark. Because they said that, I didn't read this part, that the court said that they did an independent review of the record and said that it disclosed no other potential issues for appeal. And I was like, well, wasn't that nice of them to decide that he had no other issues? So that was all it was. Confused myself. Now here's where they're arguing about the due process, and this is where they're going to talk about the case law. And was it a violation under established case law? Addressing Dodge's due process claims on the merits, they concluded that the state did not violate his rights. The state's failure to preserve evidence, blah, 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 is the same thing I said before. Failed to preserve, that is apparently exculpatory, and if it's potentially exculpatory, then you have to establish bad faith. Dodge first contends the blood samples were apparently exculpatory. To establish that evidence was apparently exculpatory, a defendant must demonstrate that the evidence possessed an exculpatory value that was apparent to those who had custody of the evidence before the evidence was destroyed. It is not enough to allege the evidence had the possibility of being exculpatory. In other words, evidence does not have apparent exculpatory value if analysis of the evidence would have provided simply an avenue of investigation that might have led in any number of directions. And that comes from the Seventh Circuit case, Hugh Biggs versus Frank, which was actually quoting Arizona versus Youngblood. So, yeah, that's why I said that he's not going to win on apparent exculpatory claim, because it's not apparently. The testing could lead to what he wants it to lead to. Then they cite Parker. Now, Parker is interesting because Kathleen cited it as well. It's not a case about biological preservation. It's a case about some tapes that were erased or lost, some audio tapes. A dog. And then, yeah, say, God, again, they say that our reasoning in State versus Parker is instructive. We rejected Parker's argument, reasoning the tape's exculpatory value could hardly be considered apparent, given that both Parker and his attorney reviewed the tape before trial and declined to introduce it as evidence. We concluded a defendant may not sit back while evidence is available and then argue for a new trial on the grounds that evidence is no longer available to him. But, as I said before, will this reasoning apply to Steve's case? It shouldn't, unless they try to say that the trial counsel should have conducted their own testing of the bones. But again, should they have been required to when the state already did the testing? And they had no reason to think that their testing would do anything different, because they didn't have any resources or any technology that could do anything better than the state did. Okay, moving on. And in Parker, obviously Parker and his attorneys actually heard the tape before it was destroyed. So they knew it was on it. And it was determined in that case that, well, neither one of them could say that it was anything that was really exculpatory. It says, furthermore, based on the evidence introduced at trial, the sheriff's department, the sheriff's department had no reason to believe the blood samples were exculpatory at the time they were lost or destroyed. Although Dodge argued at trial that the victim died from injuries he had sustained several days earlier when he fell down the basement stairs, the circuit court found that the evidence did not support Dodge's theory. So saying that Dodge had a theory, okay, and he said that, well, those bloodstains could belong to the victim. There's a lot of other evidence that contradicted his theory. So they're kind of saying, like, well, this is like a fishing expedition. Now, again, when it comes to Steve's case, the state provided a lot of what they called evidence that Teresa never left the property. But Steve presented evidence that he did, that she did, and they even suggested that the burn event could have happened in the quarry. Kathleen's theory certainly suggests she left. So they can't say that Steve didn't present a theory that would make these bones important at the time of the trial, because he did. They actually mentioned the importance of them. There was simply no evidence at trial supporting Dodge's theory that the victim's death was caused by a fall down the basement stairs. Consequently, any exculpatory value the blood samples had would not have been apparent to the sheriff's department. At best, Dodge has shown the blood samples had the possibility of being exculpatory. A showing that evidence was merely possible possibly exculpatory is insufficient to establish apparent exculpatory value. Duh. Dodge next contends that even if the blood samples were only potentially exculpatory, the Sheriff's Department acted in bad faith by failing to preserve them. He pointed out the circuit court found the blood samples were unavailable for testing because the Sheriff's Department failed to follow its own evidence handling procedures. Dodge argues the department's failure to comply with these procedures necessitates a finding of bad faith. We disagree. Without more, the department's failure to follow its own procedures for handling evidence demonstrates, at most, negligence. A negligent failure to preserve potentially exculpatory evidence does not constitute bad faith. Instead, to establish bad faith, the defendant must show the police were aware of the potentially exculpatory value of the evidence they failed to preserve and acted with either official animus or a conscious attempt to suppress the evidence. Again, since they did not have any potential exculpatory value and it was unintentional, there was no bad faith, there was no official animus, and then his due process rights were not violated. Okay, I'm just gonna move on from that because I'm already bored with it. Okay, so the next part is where they argue about relief under the two statutes. Dodge next argues the Sheriff's Department's failure to preserve the blood samples violated his rights under 968-205 and 97407. He contends these violations require that his conviction be vacated. We disagree. And this is where, when I read this, my jaw was on the floor. I just could not believe that a court could rule this way. It's ridiculous. Okay. And if I had done this yesterday, you would have seen me raging like uncontrollably. I don't think anyone's ever seen me pissed off in a video before, but it would have happened if I'd done it yesterday. I was just so irate. It says, even assuming the state violated the 968-205 the statute does not provide any remedy for a convicted defendant in the event of a violation. While the DNA evidence preservation statutes comprehensively detail how the state law enforcement agencies must preserve biological evidence, they do not provide a remedy for convicted individuals in the event of a violation of the statute. Accordingly, the state's violation of 968-205 does not entitle Dodge to the relief he seeks. Are you kidding me? Are you kidding me? They're saying that since there's no remedy listed, he's not entitled to any relief. This is a law, an actual law. Statutes are laws, okay? And they're saying that, oh, well, they may have broken the law, but we're just not going to do anything about it. It's ridiculous. It is ridiculous for the court to say, well, since they didn't spell it out for us, you're not entitled to any. Then why have this law? It is essentially a phantom law. It's not a real law, apparently. And I don't care where you stand on this case, you have to know that that's ridiculous. That is a ridiculous reasoning to not punish somebody or grant relief to somebody for breaking the law. But that's exactly what they did. And then this gets even better. Dodge also fails to explain how he is entitled to relief under 97407. That statute, which describes how a defendant may obtain post-conviction DNA testing of evidence, only applies to evidence that is in the actual or constructive possession of a government agency. Do you want to just take one guess where this is going with the rest? It's pretty obvious. Here, the Sheriff's Department no longer possessed the blood sample evidence when Dodge filed his 97407 motion, so the statute does not apply. Yeah, it's not in their custody because they destroyed it. It's just ridiculous. I just kept thinking, are you kidding me when I was reading this? I mean, they're not wrong. I mean, they're right. It's not in the possession of the government because they destroyed it. I was sitting there thinking, like, this is just a dangerous message to send. They're basically saying that law enforcement can destroy whatever they want. There will be no consequences. There will be no relief for anybody. And that it doesn't matter if the intent is to be able to allow post-conviction DNA testing, because if they don't have the evidence, you can't do it. Doesn't matter if it was destroyed. It's the craziest thing I've ever read. Okay, let's see. I know I was just going on and on. Okay, so the most important part about this, though, and I had to laugh when I saw that in Reddit, he was like, this precedent that's set in Wisconsin, and they were so proud of themselves that they found this case. First of all, it wasn't that hard to find. Second of all, it's actually not precedent. It's not. It doesn't set a precedent. And the important part of this, the best part, is that the very, very, very bottom, this opinion will not be published. And it's also a per curiam opinion. That means it is not binding precedent and that it can't even be cited by the state. Because that was one of the things in the post, says, I can't wait for the state to cite this case. Well, keep waiting, because they can't. So it's not a case that can be cited unless it deals with claim preclusion, which it actually does, but they're not going to cite it for that. And if it was, if a single judge of the 3-judge panel had put their name on it, even though it's per curiam, since it's per curiam and that not a single judge signed it or put their name on it, it can't be cited, period. That's why this case has never been cited before. And it's also why I'm pretty sure that Kathleen's aware of this case. I thought about sending it to her and being like, could this be a problem? But then when I looked back at the footnote that she has in the motion, she's very careful to say there have been no published opinions addressing this statute since it was enacted. And she's right. This is the only one. And what's interesting to me, first off, the good news is this is a District 3 case, District 3 Court of Appeals, and none of the 3 judges that wrote this opinion are even on the bench anymore. At least not the appellate bench. Thank God. Can you imagine? I mean, what sucks about it is that they're not technically wrong about it. It's just so ridiculous. I mean, again, the legislature does not create laws so that people can just break them with no consequences. It's stupid. Yeah, I'm sure I'm going to get made fun of a lot by some of the guilters if anyone watches this. Hopefully they won't. I don't care. I'm not wrong. I mean, they made a big deal. They put right in the title, precedent setting case, and then he put oh, can't wait for them to cite it. Haha, and everybody was congratulating. I'm sorry, but actually know what you're talking about first. Okay, you found a case, great, but do you know what the case means or what potential future meaning it has? It has none. So stop getting so excited about it. It's a stupid case. And so you're probably wondering, why did I make you sit through that? The reason is because, to me, it's still important for the fact that it shows how scared, in my opinion, the Wisconsin courts are to address this statute. Again, it's been 17, almost 18 years since the statute was enacted, and there's never been a case, not one, that has been heard on this, not in the higher courts. That's crazy to me. Why are they avoiding it so much? It just seems like they're purposely avoiding having to address the statute. And if I had to guess why, it's because it was never created with the intention of actually helping to exonerate somebody. Not exonerate even, just to overturn a conviction. I mean, it's the same thing basically. But some cases, people have to have their convictions overturned that are guilty, and they're retried and they're found guilty again. So I don't want to use it synonymously because it's not the same thing. But they just don't want it to be used. They don't want to give people who are prisoners one more opportunity to try to overturn their conviction. And they know if they set a precedent after the statute is created, it can open up a whole bunch of cases that could be overturned. And the fact that they went to the trouble of writing all of this, they could have stopped after saying he was procedurally barred. They didn't have to write any more than that. They went to the trouble of writing it, but then they purposely unpublished it and didn't put a name on it so that it couldn't be cited. It's strange to me. It's like this state is, like I said, I feel like they're actively avoiding addressing this issue. Most of these preservation cases that I'm reading about, they said the statute doesn't apply. They either took place before the statute was enacted, or since the statute was enacted, they're dealing with biological samples that belong to the defendants, not the victims. So I don't know what they're going to do with this, because until the legislature actually modifies it to add some kind of remedy, is that when it's going to matter? To me, it's exactly what Judge Brown said in the Weisinger ruling about the bad faith part of Youngblood. It's just saying, like, this is an illusion. The statute is an illusion. It's an illusion that we're going to give people a chance on post-conviction to help themselves. But we're really not going to. Nobody wants to take that step. And I understand that relief is difficult to quantify. It's hard to say because each case is unique. And you can't just have a catch-all remedy for violating that statute. So you're stuck with the courts being able to determine for themselves. Well, in this case, they just decide not to do anything. I was like, and that is, again, sending the wrong message. Thank God it's not presidential, but it's still a horrible message to send. Because what's to stop law enforcement from just destroying anything they want? There isn't anything, as far as I'm concerned. Okay, you guys are all just saying hi. Now nobody's, when I actually am done talking, nobody's asking questions. So yeah, so that's my take on it, is that I really feel like the state is trying to avoid having to deal with this issue. Steve's case is very unique. The circumstance and the facts surrounding these particular bones, and how they were brought up, and I mean, they have to evaluate this. There is no, like I said, blanket answer like, no, we're not going to grant a hearing, and no, you don't get relief on this. It has to be evaluated, especially since the statute doesn't allow for relief. That means that a judge has to look at it and has to do a full analysis. So again, the good news is that, like, I still stand by the fact that they're going to remand it. Again, I keep saying there's no reason, and people will be like, oh, there's a bunch of reasons. No, there really isn't. There's no legal reason, and they don't really have any leg to stand on if they deny the remand. And it should be granted a hearing. I hate that I can't trust this judge, because any other judge would probably grant a hearing in a heartbeat. You have to. Because Steve can't win on the first part of the statute. He can't win on the part that says that you have to preserve biological material that belonged to the victim. Because you don't know. We don't know that they belong to the victim. I know Kathleen put that they're suspected. That's not enough. She knows it. So they have to win on the second part. That was it reasonable for them to dispose of them, knowing that they could potentially have exculpatory value? Did they know they potentially had exculpatory value? That's the part that she has to win on. And that's why it's a subjective decision. And so a judge has to take in facts from both sides before she can rule on it. Hi, guys. Well, thanks, Sandy. What? You're showing up right when I'm finishing. Okay, so that's about it. That's really all I wanted to say. And I know, again, that it was really dry and that it was probably a lot of technical information, and my reading isn't always the best because I get bored reading after a while. But do you understand at least where I'm coming from or what I was trying to show? I mean, I'm trying to show that the pattern under Youngblood is not good. It doesn't give you a lot of hope. It really doesn't. But there's a lot that's going on that does still give hope, because there have been so many issues with this case law. And like I said, the courts have been shying away from addressing this statute. Now, could Steve's case finally be the case where they're like, yeah, we finally need to do something about this? Because it shouldn't have to stand on case law, because there has been a law created since that case law. So it shouldn't always be standing on, because I feel like they use Greenwald and in turn Youngblood to deny a lot of this stuff, and because of the bad faith requirement. And well, then, again, what's the point of having this preservation statute law? You have a statutory reason to address this issue now, not under just case law, and they're refusing to do it. So I hope people make it to the end. Is it always going to be the same judge? For now, I mean, they have to get through the appeal. He can't get a substitute judge in the middle of an appeal, and it is still mid-appeal. There has to be a resolution to the appeal one way or the other before he can request a substitution. I don't really think, let's see, if they don't remand there isn't an appeal of that decision, and then we go back to the original appeal. This would be added to the appeal. Assuming, well, are you saying if they don't remand? Yeah, I'm sorry. If they don't remand, then no, this would not be added to the appeal, but she could bring it up later on. There should be no procedural bar issue because they're the ones that kept her from presenting it. So it'd be really unfair for the court to say, well, now you're barred, even though she's trying to present it at the appropriate time. That's why they should allow it. Is it a chance that's tricky? I'm not going to get into that. I mean, honestly, I'm big on not screaming corruption unless you have actual evidence of it. Incompetence, yeah, for sure. Incompetence, part of the judge, a part of everybody, but and I know there is corruption within law enforcement for sure. But as far as the courts go, I don't ever scream corruption unless there's evidence of somebody being corrupt. I think Judge S is an idiot. I do. I think she's just terrible, a terrible judge. It doesn't mean she's corrupt. It just means she's inept for sure. She could be. I don't know, but I won't address it because I don't like falsely accusing people. I don't mind accusing her of being an idiot because she is. Okay, people have been talking about like, could they exhume the bones and things like that? Well, yeah, but I honestly don't even think it's going to get to that point. I mean, no court is going to order an exhumation unless you have a significant reason to do so. The only reason that they'd have significant reason is if they felt that they truly held a chance of having exculpatory results. Well, if they thought that, then they just overturn it on the due process violation. I mean, they're not going to say, no, your rights weren't violated, but we're going to exhume these bones. No, it's not going to work that way. So if he loses, they're not going to do anything. And if he wins, there's no reason to do it. But there is not a clear-cut statute on exhumation and chain of custody in Wisconsin. There are not many cases, actually. Only one, really, and that was from the 80s. And that one, there was no discussion of chain of custody. It was just, we need to exhume the body. They did it, and that was it. I think I answered that, Allie, yeah. If this gets denied, is there more to move forward on? Well, they'd move forward on the original appeal, the one that's still pending. Travis, you're a lawyer, so of course you'd think it was great. You like all this technical stuff like I do. Thanks, Kim. Yeah, Travis just said it's a wonder there are any exonerations in Wisconsin at all. And yeah, I agree. Again, the only reason why Steve was allowed to do new testing on the hair comparisons in the 1985 case is because the government decided that hair comparison samples was junk science. And even then, they weren't going to overturn his conviction over it. But since hair comparison analysis by Sherry Culhane was used in the first trial, they had to at least give him the opportunity to test those hairs again. And that's when they discovered that the pubic hair belonged to Gregory Allen. So if that hadn't happened, he really wouldn't have much recourse. And thank God they didn't destroy them. Surprised they didn't. It's not dry. I'm sure many people do, but I'm hoping that people don't. I hope you like sort of get it, what I'm saying. Allie, you're another one that I could say like, yeah, I know. You don't have to say that because I know you love this stuff. Thanks, Cindy. Okay, well, I'm gonna let you guys go. I have to eat. My family ate without me. So I need to go eat, but I will answer questions maybe later tonight. I have been for 3 days straight, like just reading stuff on this case and everything and dealing with all the notifications from the last videos and everything like that. So I need to take a little bit of a break. So, but yeah, I will get back to it. And tomorrow we have the Q&A. I should mention that Kathleen tweeted that she's going to do a Q&A tomorrow. So there's going to be a lot more going on with that. So I'm taking a little bit of a break the rest of the night. So hope you guys understand. But I will try to answer questions still. But okay, that is it for now. We love you. I love you guys too. Well, Sandy, I love you. You know that. Okay, then I will talk to you guys soon. Bye.